We first mentioned the CCPA back in June of 2018. Now everyone is finally panicking that the California Consumer Privacy Act that's going to land in January of 2020. It's the biggest data privacy shakeup in United States history. But what does this all mean for your business? When can enforcement actions actually begin against businesses? How likely are claims against businesses for CCPA violations to actually occur? Let's break each of these down. The CCPA authorizes two types of enforcement actions. First, the Act gives the California Attorney General the power to bring civil actions against businesses that fail to comply no sooner than 6 months after the final publication of the CCPA, or July 1st of 2020, whichever comes first. However, given that the regulation has not been finalized yet, the Attorney General's enforcement will likely begin on July 1st of 2020. But before you get too excited, the Attorney General will likely be able to retroactively bring actions for CCPA violations dating back to the Act's January 1st, 2020 effective date. The second type of enforcement action authorized by the CCPA is the consumer's private right of action. Unlike the 6-month delay in state enforcement actions, the consumer's individual right of action will ripen when the clock strikes midnight on January 1st of 2020, allowing consumers to immediately bring civil actions for actual damages suffered as a result of an alleged violation. On December 10th, just weeks before the CCPA is set to go live, California Attorney General Xavier Becerra stated that if a company is not making an effort to comply, then he will, in his own words, descend on them and make an example of them to show that if you don't do it the right way, this is what's going to happen to you. More than ever, it is crucial that organizations have a well-constructed and comprehensive data privacy compliance program that can address the growing risks of privacy laws around the globe.